Hello and welcome to our Hogan Lovells video series on digital transformation and law. My name is Florian Richter. I'm an attorney and senior associate in the Hamburg office of Hogan Lovells, and you are watching the second session of our webinar series on the EU Digital Services Act. In our previous session, we provided an overview of the legislative history, the key aspects and core principles of the DSA. We also discussed what brings the service in scope of the new law, a question that is often not as easy as it should be. In this context, we particularly looked at the substantive scope and the four service categories established under the DSA: intermediary services, hosting services, online platforms, and very large online platforms, or very large online search engines. In today's session, we will explore the DSA's principles for intermediary liability, or more specifically, what the DSA regulates in terms of liability of providers for illegal content uploaded by their users. We will explore in a few minutes that, contrary to what some stakeholders had hoped and lobbied for, the DSA doesn't change too much in this regard. On the contrary, the DSA maintains most of the liability rules from its predecessor, the e-commerce directive. And yet, provider liability is one of the most dynamic and evolving topics at the moment. Courts, both on European and on national level, are continuously developing new liability principles in one precedent after the other. So when we speak about the liability principles of the DSA, we will also need to talk about the surrounding case law. And that's exactly what we will be doing today. Let's dive in. When we talk about liability of providers of digital services, it is important to distinguish at the outset between what we call 1P content and 3P content. 1P content is information that was created and uploaded by the provider directly, or on the provider's behalf. An example would be product listings on a marketplace that are offered and sold not by a third-party trader, but by the marketplace provider itself. For such 1P content, the provider is primarily liable in case of an infringement. So in our example, the provider would be as responsible and accountable for a listing as any third-party trader would be for their listing. 3P content, on the other hand, means information that stems from third parties. This is content that is created and uploaded by users and which is only intermediated by the service provider. This includes all sorts of information which we usually refer to as online content, such as posts on social media, product listings by third-party traders, customer reviews, shared videos, etc. Providers typically don't have specific knowledge of the individual pieces of such content. They only provide the technical infrastructure allowing for the storage and dissemination of such content. And therefore, providers were traditionally not considered primarily liable for 3P content, but only secondarily liable. A secondary liability often means in this context that additional liability requirements must be met, or that providers are subject only to a subset of the remedies compared to the primary infringer. Now, the tricky thing is that secondary liability is not fully harmonized in the EU. The rules on secondary liability differ between the member states, and as we will see later on in this session, this has in fact led to a trend in European case law towards primary liability, in the sense that providers are more and more deemed primarily liable for the content that was originally uploaded by their users. That said, what is harmonized on EU level is the conditional liability exemptions for 3P content. This means that we do have uniform European rules setting out the conditions under which providers cannot be found liable for user content. These liability exemptions are also known as safe harbor provisions and can now be found in Articles 4 to 6 DSA. Article 4 applies to mere conduit services like internet access providers. Article 5 concerns caching services such as content delivery networks. And Article 6 is for hosting services and online platforms. These liability exemptions are accompanied by the so-called prohibition of general monitoring obligations in Article 8 DSA. We will learn more about Article 6 and 8 in a few minutes. These core liability rules apply horizontally. This means they are equally applicable under civil, administrative, and criminal law, and for all forms of liability. But of course, a court or an authority are not restricted from ordering the provider to terminate or prevent a specific infringement occurring on the service. As mentioned before, all of this is not really new. The liability exemptions under the DSA are largely identical to the previous rules under the e-commerce directive. So the EU lawmakers decided against completely revamping the previous provider liability system, and instead the system is only tweaked here and there to a limited extent. What is new on first glance is the introduction of the so-called Good Samaritan principle in Article 7 DSA. This principle sets out that providers shall not be deemed ineligible for the conditional liability exemptions solely because they engage in voluntary investigations of user content. The idea here was to incentivize providers to take action against illegal content on their own initiative. Unfortunately, however, this idea was implemented very poorly in the DSA, especially because the knowledge obtained about illegal content in the course of such voluntary investigations can still trigger legal obligations and liability for the provider. Having laid the groundwork, let us now briefly look at the sources of law that can make 3P content illegal. Well, the possibilities are almost endless, but here we can see the legal areas that we consider most relevant from our expertise and practice. Infringements of intellectual property rights deserve a special mention here, because IP infringements shape the European case law on intermediary liability the most, and by far. Almost all key precedents at European level from the last 15 years revolved around trademark and copyright infringements. Depending on the type of online service, some areas of law are obviously a little more important and topical than others. For instance, for online marketplaces, violations against product safety, product compliance, and unfair competition rules play an ever-increasing role. A trend that will certainly continue under the EU General Product Safety Regulation, GPSR, which became applicable in December 2024. Whereas for social media services, the focus will continue to lie on personality rights violations, illegal hate speech, and the protection of minors. Services like online marketplaces, social media platforms, also video sharing services, would arguably not be operable in Europe if it wasn't for the hosting privilege. The hosting privilege forms a key defense for providers of hosting services and online platforms of all sorts, and makes the intermediation of user content at a large scale legally manageable. The concept behind the hosting privilege is quite simple. A hosting service provider is not liable for 3P content stored at the request of a user if that provider does not have actual knowledge of that content and its illegality, or, upon obtaining such knowledge, acts expeditiously to remove or disable access to that content. So as a rule of thumb, providers of hosting services can avoid liability for illegal content when they act quickly once becoming aware of it. Actual knowledge in this context means positive knowledge of the specific content in question. In contrast, a general awareness of the provider that its services are also used by some users for illegal activity does not trigger liability. The illegality of the content must be readily apparent for the provider, which is the case when that illegality can be established without conducting a detailed legal or factual examination. This is a qualitative threshold that was often not sufficiently regarded by the courts in the past, and which was now reaffirmed explicitly in Article 16.3 DSA, as well as in recent CJEU decisions. Contrary to popular belief, though, the requirement to act expeditiously is generally not tied to specific deadlines, and rightfully so, as some instances of illegal content can be more complex to identify and address than others. However, there are exceptions to this rule. For example, Article 22.8 of the GPSR explicitly prescribes that online marketplaces must take action within 3 working days when made aware of specific product safety issues in a sufficient manner. While the hosting privilege is generally available to any type of hosting service, there's one important caveat. Hosting providers that play a so-called active role that gives them knowledge or control over the content in question are not eligible for the hosting privilege. This is an unwritten rule that was developed by the CJEU in landmark decisions in 2010 and 2011 on the basis of recitals to the e-commerce directive. In essence, this rule means that when a provider leaves its neutral and passive position and becomes too active with respect to the specific piece of content in question, then this provider is at risk of forfeiting the hosting privilege as a key legal defense. We can tell from our daily practice that drawing the line between a neutral and an active role can be very difficult at times. And in fact, the active role criterion is more topical than ever, as hardly any online platform provider remains 100% passive these days. On the contrary, there's a rightful expectation from users of all kinds that providers offer some sort of assistance when presenting their content, such as through the use of AI. A provider who doesn't offer such additional features to its service runs the risk of falling behind its competitors economically. So eventually, there are a number of policy questions behind the active role criterion, such as how much assistance shall a provider be able to give before potentially becoming liable for user content? Do we want to motivate or demotivate providers from launching helpful additional features in Europe? Questions like these will have to be answered by the courts and lawmakers alike, especially in light of the ongoing rise of AI. Last but not least, it is worth mentioning that the DSA introduces another very specific caveat from the hosting privilege in Article 6.3. As per this provision, providers of B2C marketplaces cannot invoke the hosting privilege for liability under consumer protection law when the illegal information appears to have been published by the marketplace itself in the eyes of the average customer. This new exemption touches on the distinction between 1P content and 3P content that we discussed earlier in this session. And it remains to be seen here if and how this new rule will have an impact in practice, because eventually it only removes the hosting privilege. It does not automatically declare a provider to be primarily liable. When we talk about the hosting privilege, we also need to briefly look at the prohibition of general monitoring obligations, because the two principles are intertwined. The prohibition of general monitoring obligations was already introduced with the e-commerce directive and can now be found in Article 8 DSA. It sets out that no general obligation to monitor information, nor actively to seek facts or circumstances indicating illegal activity, shall be imposed on intermediary service providers. In other words, providers cannot be legally required to screen the content of all their users for potential infringements. They do not have to provide themselves with the knowledge of illegal content that might trigger the liability and obligation to take down content. Of course, providers are free to voluntarily do so as part of their own initiative content moderation as they see fit, but they cannot be made subject to a legal obligation in this direction. So far so good, but what is tricky in this context is drawing the line between general monitoring and specific monitoring. Specific monitoring obligations are compatible with Article 8. So for instance, a provider could very well be required in a court order to monitor and prevent a certain user from reposting a specific piece of infringing content again. But when such order is not confined to a specific piece of content, nor to a specific group of users, then this order arguably results in a prohibited general monitoring obligation. Case law from the CJEU does provide some guidance for the distinction in this context. In its two SABAM decisions, the CJEU specified that the ban on general monitoring obligations is supposed to strike a fair balance between the rights and fundamental freedoms of all parties involved. So the right owners, the users, and the intermediaries alike. And that the courts are precluded from imposing filtering systems onto providers which apply indiscriminately to all users and their content as a preventive measure exclusively at the provider's expense for an unlimited period. So when a provider is facing a court order or also a new statutory requirement that checks all these boxes, then this order or requirement would be incompatible with the prohibition of general monitoring obligations. Since all of this was quite theoretical, let's have a quick look at what these liability exemptions and the hosting privilege in particular mean in practice. The most important consequence of the hosting privilege is the so-called notice and takedown or notice and action procedure. Following this procedure, providers of hosting services and online platforms must take in and assess notices from right holders and others on suspected illegal content. If the providers then come, or should have come, to the conclusion that the reported content is illegal, they must take action against it. As we will explore in later sessions of our webinar series, the DSA introduced various new procedural requirements revolving around the notice and action regime. For example, obligations to duly inform the affected parties, to allow for complaints, and to engage in mediation. Today, we are keeping it short and simple by focusing on what a notice under the DSA can look like, how it must be assessed by a provider, and what action the provider must take to successfully invoke the hosting privilege and to avoid liability. So as the name says, the first step of the notice and action procedure consists of a right holder or another eligible entity sending a notice to the provider about the presence of illegal content on the provider's service. The purpose of such notice is twofold. On the one hand, the notice shall put the provider in a position to easily identify the illegality of the content and to take action. And on the other hand, it shall pave the way for holding the provider accountable in case that provider does not take action without undue delay. A notice can come in various different forms, not all of which are specifically regulated by the DSA. In fact, the DSA specifies the modalities only for the submission of electronic notices via online reporting forms and similar intake channels. That said, a notice can also consist of an email or a letter, which is the form that we lawyers resort to for more sophisticated types of infringements that require some more explanation. Court orders and other legal documents can also form part of a notice. Indeed, a court order declaring a specific product or statement illegal can often facilitate the legal assessment and make a complex infringement readily apparent. And finally, own initiative investigations can also have the same effect like a notice, as they may equally give the provider sufficient knowledge about an infringement. In a second step, the provider must process and assess the notice. The DSA says that the provider must do so timely, but again, without imposing fixed deadlines, and that the assessment must be diligent, non-arbitrary, and objective. As established earlier, providers are not required to conduct detailed legal or factual examinations in this context. It is the responsibility not of the provider, but of the notice submitter to explain the illegality in such a way that it can be easily established by the provider. If the notice falls short of this requirement, or if the provider would have to consult a lawyer to make sense of a notice, then the provider can reject this notice as insufficient. An interesting open question in this context is whether the notice must also establish clearly why the notice submitter has legal standing for reporting the content in question. Pre-DSA, the German Federal Court of Justice has answered this question in the affirmative. As we will learn in the next session, however, Article 16 of the DSA says that, in general, any individual or entity shall be entitled to submit electronic notices on illegal content. This raises interesting questions such as, why should Jane or John Doe be able to report the violation of a right that the actual right owner does not care about? Why should they have the power to enforce that right against the provider out of court when they could never enforce that right in court due to a lack of standing? The DSA regulators will have to find convincing and consistent answers to these questions, while also allowing for a well-balanced approach. Finally, in the third step, and after the provider established that the reported content is indeed illegal, the provider must take action. This action at least consists of taking the content down or disabling access to it in the jurisdictions where it is illegal. This follows clearly from the DSA itself, as well as from the relevant CGEU case law. What is far less clear, however, is whether the providers are also required to take action beyond a simple takedown. In Germany, for instance, the courts have established long ago, before the advent of the DSA, that providers must also take action against identical and essentially similar content that already exists on their platform, what I like to call an extended takedown obligation. And even one step further, German courts repeatedly held that providers must also prevent identical and essentially similar content from reappearing via stay-down measures. Now, it can be seriously put into question whether these far-reaching obligations, following a notice under German case law, are compatible with the DSA. The DSA does acknowledge stay-down obligations for providers, but only as a result of a court or authority order. It can be argued in this context that the DSA wants the courts and not the providers to handle the difficult assessment of what is essentially similar and which measures are appropriate in light of the rights and interests of all affected parties. In fact, the legislative history of the DSA supports this argument, as the introduction of a recital on stay-down obligations was rejected by EU lawmakers at the very last minute. It is arguably only a matter of time until this specific question is referred to the CGEU. So all in all, and as we established earlier in this session, the DSA doesn't actually change that much when it comes to the provider's liability for illegal user content. The previous rules from the e-commerce directive have been maintained and tweaked only marginally. That said, the question of when providers become liable and how is far from settled. On the contrary, courts on both EU and member state level are constantly dealing with new questions and finding new answers when it comes to intermediary liability. Let's have a look at some of the latest precedents. As we noted earlier in this session, there is a clear trend in the latest European case law to hold intermediary service providers primarily liable for user content. This means that the courts are increasingly starting to deem the provider to be the infringer under specific circumstances, although the content in question was initially uploaded by a user. The result of this trend is that intermediary service providers are potentially becoming liable for damages and other remedies, which typically go beyond the claims under the principles of secondary liability which applied in the past. You may also recall from earlier that we said that IP infringements have always been the driver for case law developments on intermediary liability. Now, this holds true as well for the latest expansion of primary liability. For example, the CGEU decided in its 2021 landmark decision in YouTube and Zalando that providers of video sharing and share hosting services can be held primarily liable for the public dissemination of copyright infringing content following specific requirements. In this context, the CGEU developed three distinct case groups, which we will analyze shortly in a bit more detail. The guidance from this precedent was then picked up in 2023 by the Cologne Higher Regional Court in Germany, where the judges applied and expanded the liability principles from YouTube and Zalando to name servers and content delivery networks. Shortly after, the German Federal Court of Justice made a similar expansion and applied the guidance from YouTube and Zalando to copyright infringing content on online marketplaces. In parallel, there has also been an expansion of primary liability in trademark law. Here, the CGEU held that hybrid online marketplaces can be considered liable for trademark infringing listings if a well-informed and reasonably observant user may have the impression that these listings are marketed by the marketplace provider and not by a third-party seller. Now, what is interesting here is that when we put the CGEU decisions next to each other, they don't result in a coherent liability system. The liability conditions developed for copyright infringements are completely different from those developed specifically for trademark infringements. This is not necessarily surprising, as different rights are supposed to serve different purposes, so it's only logical to some extent that there is no one-size-fits-all liability model yet. But it remains to be seen if the CGA uses the next opportunity to come up with consistent principles for intermediary liability that apply horizontally across different rights and different subject matters. Let us now go one level deeper and take a closer look at the CGU's copyright decision in YouTube and Zalando itself, and how it was picked up by the courts in Germany. The CGU established that online intermediaries can be primarily liable for disseminating copyright infringing content when these providers play a so-called indispensable role. Such role is to be assumed in three different scenarios. First, when the provider is involved in the selection of infringing content, which arguably applies only to rogue sites that aim to be used for illegal purposes. Second, when the provider failed to generally implement appropriate technical measures to prevent copyright infringements on its platform. And third, when the provider failed to take appropriate measures against specific content after being sufficiently notified of specific copyright infringements. As you can see, this third case group largely resembles the notice and action regime which we just discussed earlier. Apart from developing these three case groups, the CGU also took the opportunity to provide important clarifications on the application of the hosting privilege. For instance, the CGU reaffirmed that actual knowledge capable of triggering the obligation to act for the provider means knowledge of the specific infringing content and of its illegality, as opposed to vague general knowledge. The court also established that features like automatic indexing, content recommendations, and search functions do not result in actual knowledge of the illegal content. And finally, the CGU also reiterated that notices on allegedly illegal content must enable the provider to confirm the illegality without a detailed legal assessment, a notion which is also reaffirmed now by Article 16.3 of the DSA. Having covered that, let us now look at what the German Federal Court of Justice made out of this guidance with respect to copyright infringing content on marketplaces. Well, Germany's highest court essentially applies the guidance from YouTube and Zalando directly, but also mingles it with the traditional German intermediary liability principles. More particularly, the court held that after having received a notice on copyright infringements, the marketplace in question was under an obligation to remove the reported content, to search for and remove essentially similar content, as well as to prevent the upload of essentially similar content. And because the marketplace provider failed to comply with obligation 2 and 3 in this case, it was eventually found primarily liable for the infringements and had to pay damages to the right owner, something which would have not been a possibility under the principles of secondary liability as previously applicable. Now, this expansion of primary liability, as construed by the German Federal Court of Justice, is extremely broad. In the end, it puts a significant burden on the providers to figure out in a very short time frame what content could be considered essentially similar to the reported content and which stay-down measures might be appropriate and expected from them. As we know from our daily practice, this is an extremely difficult exercise that can vary heavily from case to case. It can indeed be scrutinized whether the German Federal Court of Justice went one step too far here, because the CGU decision in YouTube and Zalando only discusses takedown obligations, but not a stay-down. The assumption that a provider is subject to extended takedown and stay-down obligations after a simple notice can also be scrutinized for its compatibility with the DSA, because the DSA acknowledges stay-down obligations only when imposed by court order. All in all, there are many open questions that become more and more pressing with the expansion of primary liability for providers, such as what actually can be considered essentially similar content, and how much time does a provider really have to implement filters as stay-down measures? It will be questions like these that will keep us lawyers busy for the years to come. With that said, we've just reached the end of the second session of our webinar series on the EU Digital Services Act. Thank you for watching. In the next session, we will take a closer look at the DSA obligations for hosting service providers on content moderation. See you there and stay tuned.